Republican Club sponsored show for Wednesday, January 27th. Here's your host, Mark Unkelfer and Jackie Saxton. Welcome.
Well, welcome to the show, and welcome, Jackie. Welcome back. It's been a while since we've seen you, but it's great to have you. We're very pleased to have tonight our guest, who's the author of Supreme Disorder. He is at the Cato Institute, but has done some really great work on the Supreme Court, Ilya Shapiro. So thank you, and welcome to the show. Yours is a very
topic. Be on, Mark, and I'll get it out of the way right away. If anyone gets my book, and you put in the chat, supremedisorder.com, where not only can you order the book through whatever channel you want, you don't like Amazon, you don't like whatever, there's different things you can click on.
Right.
But you can also download for free a 20-page statistical historical appendix, so you can really nerd out on this stuff and be very popular at your next Zoom cocktail party or what have you. But wait, there's more. If you get the book, I'll be happy. We can't do in-person signings these days, of course,
right,
but I'll be happy to send a signed book plate to anyone who wants to stick it in there.
Well, thank you very much. I enjoyed it quite a bit. I have to say that I did it the audio way. And so I probably should have benefited from the statistical analysis, because you really do a great job of going back through history, starting with the Washington administration, and talk through the problems that or the challenges that specific presidents have had getting Supreme Court nominees confirmed. And sometimes we think that this is a new phenomenon, but it certainly isn't, is it?
No, I mean, presidents going back to Washington, I discovered right from the very beginning, have had problems. Washington had a nominee rejected. About half of our presidents have had trouble filling seats in one way or another. And politics didn't start playing a role in the nomination confirmation process with, Robert Bork in 1987, let alone, Brett Kavanaugh 2 years ago, or Clarence Thomas in 1991. I mean, which just shouldn't surprise you, because presidents are politicians, senators are politicians. They're all responding to different incentives. Now, politics clearly works differently in different eras, whether it's having to placate different factions within your own party, or geographical affiliations, or the issues of the day are different. But the idea that judicial nomination to the Supreme Court is a politically controversial thing, that is not a modern development.
But have you noticed, is that line a completely straight line if you were to graph, newer presidencies, and how much more political Supreme Court nominations have become? Has it become just steadily more, or is there an up and down period for that?
Yeah, I mean, there are some times where it's harder to confirm than others. Between Andrew Jackson and Abraham Lincoln, for example, so kind of the third generation of American governance, only 8 of 21 nominees were confirmed. It was a time when the parties were kind of realigning, and different factions and all sorts of things were going on. I tell you, I really put the hinge of kind of the past, and my book is divided into 3 parts, like Gaul, I guess you could say. The first part is the past, George Washington, until 1968. That's where I put the hinge into the modern era. The second part is the present, meaning about the last 50 years. And then the third part is what lessons have we learned? How do we look to the future? What reforms should we consider? Things like that. But 1968 is the pivotal year when judicial philosophy really became part of the consideration for nominations, as part of the political campaigns as well. Richard Nixon in 1968 campaigned on law and order and strict construction and stuff like that. And in 1968, LBJ, weakened politically, decided not to run for re-election, had a Supreme Court nominee filibustered, or at least blocked by partisan manner in the Senate. So politics has worked differently. What's new now is that you have kind of the culmination of several trends, where you have the accretion of power in Washington, so the federalization of power, and at the same time a skewing of that power away from Congress towards the executive branch and administrative agencies. And of course, if they do something that people don't like, they can only be sued. They can't be unelected. And so those sorts of issues go to the Supreme Court. The Supreme Court becomes more and more important, decides more and more important issues. And at the same time, we have divergent interpretive theories mapping onto partisan preference at a time when the parties themselves are more ideologically sorted since at least the Civil War. So, of course, we're going to have these cataclysmic battles.
You've described that hinge as being sort of also coinciding with this notion that whereas the parties used to be broad coalitions with elements on the left and the right within each of them, going forward, it's much more of the high stakes nature is the ideological component where there is definitely a conservative and a progressive or liberal point of view.
And that sorting definitely started in the late 60s, as far as you can tell, and it's only finished in the last number of years, where there's no, either in the House or the Senate, there is no more, there's no Democrat more conservative than the most liberal Republican, for example. That's an aberration historically speaking, but that's where we are now.
So I'm going to be the horrible co-host here, saying I did not get a chance to read your book yet, but I will add it to my list. But so does this book stop at Justice Kavanaugh, or does it go forward all the way towards Amy Coney Barrett?
It's funny you ask about the timing. So I turned in the manuscript at the end of March of last year. In fact, I was all set to go to Europe on a conference, and then some blowing off steam time right as the manuscript was due the end of March. And then, of course, COVID hit, and I had nothing to celebrate, nowhere to go, whatever. But anyway, so I turned it in the end of March. The editing was over the summer. I think we finalized, it went to press sometime in August. So clearly before Amy Coney Barrett's nomination, but it came out, the release date was 4 days after Justice Ginsburg passed away.
Right.
So I called the CEO of my publisher, Regnery, and I said, do you have a good alibi for Friday night? Right. And he said, there's nothing I won't do for my authors. But yeah, you can't say that the timing is fortuitous because, a legal legend died and all that. But it was remarkable for a book on the politics of the Supreme Court and Supreme Court reform to come out after a 4 days, the same time that a justice passes away, right ahead of a very polarizing election. It certainly didn't hurt book sales.
And I was, if I could, I just want to, on that particular nomination, to give you some props, because although, as you've described, it was before the death and obviously the nomination as well, correct me if I'm wrong, you pretty much called that the next nominee would be Amy Coney Barrett. You kind of describe, I don't quite know what the term was, as presumptive, or was maybe not quite that strong, but you certainly anticipated her eventual nomination.
Well, it was quite clear that she was on the shortest of lists.
Right.
So it's not, my unique brilliance, shall we say. But yeah, she is mentioned in the book because her confirmation hearing for the Seventh Circuit was an interesting moment. In fact, the Democrats really have themselves to blame for elevating her national profile. She was the one who, Dianne Feinstein, then the ranking member of the Judiciary Committee, said that the dogma lives loudly within you, which is kind of sounds like a mashup of anti-Catholic bigotry and Star Wars, right? But anyway, that's what made her kind of a poster child for the state of the judicial battles under the Trump administration.
Yeah, and I was going to mention the timing also of Justice Ginsburg's passing was I remember distinctly because I was at Rosh Hashanah dinner, and I was looking at my phone. I'm like, oh my goodness, she passed away on the Jewish New Year, and of course she was Jewish. So I thought that was also very interesting timing as well.
There were a lot of parallels to Scalia. Obviously, Scalia was February, not October, but also an election year, and also. I think it was at a time, I have two little kids at home. When Scalia passed, I only had one, and he was a very little baby. But I remember, my wife was attending to my kids, one kid then, two kids now. And it was about my turn to help with bedtime or help with something else. And then I'm like, hun, then it was, Scalia died. Now it's, RBG died. And she knew what that meant was I would be in my study for the next 3 days and I couldn't help with any family obligations. So it's quite a surreal time.
One of the things I thought you did a great job of, we usually think of the sort of progressive nominees and the conservative nominees, but you do a great job of sort of parsing the different flavors, if you will, or the different unique characteristics, which obviously has an important dynamic where some justices may be more libertarian, others will be more, say, pro-police. I'm simplifying things. But I thought some are more cautious. I think of you described Chief Justice Roberts in that. Could you kind of can you do a nickel tour, kind of encapsulating what those different styles, if you will, of what a conservative justice means?
Well, it's, conservative doesn't mean the same thing legally or judicially speaking that it does politically. So let's just say the Republican appointees have a lot of different perspectives. And as you say, Gorsuch is a little more libertarian. Thomas is more conservative. Alito is more kind of law and order, defers to law enforcement, police. Roberts is very minimalist. He prefers kind of judicial restraint to any overarching legal theory, be it originalism, what Scalia popularized, the idea that you interpret the Constitution by its original public meaning. So Roberts prefers to take baby steps rather than implementing, some sweeping theory about constitutional interpretation. Kavanaugh is somewhere in between Roberts' caution and a Gorsuch or a Thomas more full-throated originalism. And that's still, he's only been on the bench 3 years. It's still playing itself out. Amy Coney Barrett, clerk for Scalia, says that he's her intellectual mentor, and based on her academic and judicial writings, I think that's about right. So she'll be in the mix in there somewhere. But yeah, there's a lot of kind of intellectual ferment there, and any given case, you don't know exactly where they'll end up. Even if they end up on the same side, they might disagree how to get there. The Democratic appointed justices are generally more in lockstep on the more controversial cases. Now, to be clear, I'm talking about the 25% of the cases the Supreme Court hears that everyone talks about. So abortion, affirmative action, Second Amendment, campaign finance, all of those front page news type cases. It might be surprising to know that the Supreme Court is actually unanimous in about 40 to 50% of the cases. But where we have these disagreements, where the battles are, the Democratic appointed judges, even if I'm not saying they're result oriented, but their theories are malleable in a way that achieves a result, and you don't have to doubt as much where they will end up in a politically salient case.
Now, you're a little bit harsh sometimes on Chief Justice Roberts and sort of his, how shall I say, what you describe minimalism. You want to elaborate on some of those criticisms?
Sure. I wrote a cover story for the Washington Examiner magazine last July called Roberts Rules. If someone can dig it up, you can post it in the chat notes there. But this past term, there were some good examples. There was an abortion case out of Louisiana involving some regulations about admitting privileges and things like this. And it was very similar to a case in which just 4 years ago, the court by a 5-3 vote struck down those Texas regulations. John Roberts in that case was in dissent. Well, now this is with an 8-justice court. It was a 9-justice court. Roberts joins with the more progressive justices, not because he agrees all of a sudden with Justice Breyer's opinion. Breyer wrote the majority opinion that 4 years ago where Kennedy was the swing vote, but because Roberts says of stare decisis, that is the strength of the precedent. Even though I disagree with the precedent, I'm going to hold to it. And that's unusual. And it's hard. I kind of think that Roberts was being disingenuous there because in the last 5 years, he's had no problem throwing out precedent that's much deeper rooted in cases involving property rights or campaign finance or other issues, controversial issues that are longer seated and kind of deeper embedded, and yet he voted to overturn them. And here in this case, where he had previously dissented, this time he goes the other way. And it's probably because, again, he wants to extract the court from political controversy. But I tell you, his project, he's been Chief Justice for 15 years now. I don't know how successful he is. Think about the Obamacare case, for example, the first one in 2012. This is really when the scales fell from my eyes about him. in terms of rewriting the individual mandate as a tax to uphold it in that manner. He was, again, trying to be clever, trying to be minimalist, trying to defer to the political branches, leave to the political process. And that's just not the role of a judge. I think it's decisions like that. Those two, I can name others, some that go towards conservatives, some that go toward progressives, but always kind of being cagey in the analysis that, he's trying to look out for the court's legitimacy, quote unquote, but it's when judges think about those kind of extra legal considerations that they act in illegitimate ways.
So that's a good segue into my question. Just again, with the timing of your book, and it was all very, very convenient. I'm sure one of the things that wasn't covered was what happened post-election, where one of the things that I know a lot of the whole thing was a sham. The Supreme Court needs to take up this case on election fraud. That was a huge, big deal when a lot of people were very, very disappointed that the Supreme Court refused to hear what was going on in Pennsylvania, and subsequently, I'm sure what a lot of the very strong Trump supporters were hoping was to overturn the election. So what's your take on what went on there, and maybe how that relates to what you just discussed?
That's another John Roberts story, actually. Of all the stuff that was thrown at the court or at the courts, there's only one decent case. And that was from Pennsylvania, the one that got to the court a couple of weeks before the election on an emergency motion to stay the order of the Pennsylvania Supreme Court to allow ballots to be counted that arrive after Election Day and without signatures on them. Okay, that was this Pennsylvania Supreme Court reinterpreting Pennsylvania law. And there's a live legal question that's never been resolved as to when does a state judiciary act so out of the line, kind of so egregiously in interpreting state law, not interpreting federal law, but interpreting state law, that it becomes a federal constitutional problem. Because the federal constitution says that the state legislature writes election law. Well, if the state Supreme Court effectively rewrites it, does it become a due process problem or one of the other structural protections for state legislatures that exist in the federal constitution? Anyway, the Supreme Court split 4-4. This is after RBG died, before Barrett was confirmed. The Supreme Court split 4-4 with Roberts joining the progressives. And I think if this case had been adjudicated and decided before the election, it would have forestalled some of the craziness afterwards. Now, the rest of the cases, and this case, by the way, is still pending. Like, that was an emergency stay. It's still pending. The petition is still pending before the court. They could, and I hope they do take it up, not because it will affect the results of the election or even the Pennsylvania electoral vote, but because this will come up in future elections again. It'll be good to have that question resolved. But the other stuff that was thrown at the court, I mean, these were not serious things. There's a reason why not just Republican appointed judges, but Trump appointed judges uniformly rejected all of the lawsuits brought by Trump's election lawyers. In a sense, Trump's judges were more serious lawyers than his lawyers. The Texas lawsuit got a lot of publicity, but really what Texas was saying there is, we don't like the way that ABC state run their elections. Well, most of the time, Texas doesn't like it when other states point fingers at it about how it runs its own affairs. And so there are serious issues there. So that was, I think, absolutely correct. But again, look out for this Pennsylvania case that the court might still take it. But again, this is, Mark, you said I was a little harsh on John Roberts. Every time he tries to fix things, he tries to pull the court out of the way, it ends up blowing up in his face. I mean, he is a JV politician. He's a, very smart legal mind. But when he tries to do these calculated things, it doesn't work.
You make a good point on that. Now, this sort of following up on this, you describe it as being minimalist. Sort of one of the, but maybe I'll ask your opinion on this. But I assume one of the emerging issues is going to be the role of administrative agencies. And this is this Chevron Doctrine. This is the idea, if I can simplify it, that courts will defer to expert administrative regulatory agencies in the decisions that they make, unless they're so egregious that they're simply outrageous. Now, there's a kind of background on that, and maybe I'll stop there, but as I think you talk about, there's sort of emerging jurisprudence on that might challenge that doctrine. The relevance, of course, is that we go into a new administration, and we'll end up with another set of fights on sort of administrative decisions, and that could well make its way through the courts. I'll stop there and let you kind of pick up the ball from there.
Yeah, this is definitely one of the themes in my book, that the centralization of power in Washington and the skewing of it, in the sense that Congress passes these broad laws that say the secretary of such and such shall decide, shall determine. So most of the rules by which we live our lives aren't legislation, they're regulations promulgated by agencies. So you don't like some aspect of Obamacare, chances are that's not the text of the Affordable Care Act as enacted by Congress. That's some regulation passed by the Department of Health and Human Services or Treasury or Labor Department or something like that. And the same goes for if you're a developer and you're stymied by the EPA or some other agency, that chances are that it's not in the Clean Air Act, the text of the Clean Air Act or the Clean Water Act or whatever. It's some regulation or an interpretation of a regulation that a relevant agency is doing. So there's a number of both academically and in terms of litigation that's been ongoing in the last decade or more that's pushing back on the power of this administrative state. One of these areas is, you alluded to one of them, deference doctrines. That is, how much should judges just defer to agencies? Unless they do something totally off the wall crazy, we'll just let the agency do it because they're the experts. Who are we judges to second guess that? In other words, if there's, the range of plausible ways to apply a statute is kind of A through F, that's fine. As long as the agency chooses one of those, it's okay. As long as they don't do, X,
Right.
So that Chevron deference is deferring to an agency interpreting its operative statute. There's another kind of deference that the Supreme Court recently took up called Auer deference, AUER, in a case called Kaiser versus Wilkie. This is deferring to agencies when they reinterpret their own regulations. So it's not that they're interpreting what Congress did, but they have some sort of regulation and then they reverse it or they change it or they reinterpret it. So how much should courts defer to that? And the Supreme Court ended up ruling 5-4 not to throw out this deference. That is, judges should continue to defer. But the way that Justice Kagan for the majority wrote this opinion really tightened the screws. So it really should be called Kaiser deference. Justice Gorsuch for the more conservative justices dissented and said, no, we need to throw this out. This is hogwash. Interestingly, John Roberts joined the majority and said there's actually not that much difference between the majority and the dissent. And Justice Kavanaugh, who joined Gorsuch in dissent, also said there's not that much difference. Why am I getting into the weeds like this? Because if courts are going to start, it doesn't matter whether technically it overturns the deference or it upholds it, but if courts are going to start scrutinizing more the decisions of agencies, for example, deferring to their scientists or economists or biologists, but not to their lawyers, that's a good step because, of course, judges are as good or better lawyers than agency lawyers are in terms of interpreting regulations or statutes. So anyway, that was about deferring to regulatory interpretations. Chevron is going to come up about deferring to statutory interpretations. And John Roberts, I could see him saying judges should defer less because here we really are concerned with Congress's work. And our judgment about Congress's work is more important than some agencies, and because we're trying to be faithful. Anyway, we'll see where that happens. A kind of a related, sorry to go long in this, but this is like the key to understanding the battles with this very important administrative state, is the idea that Congress, as I said, punts all of the big controversial political detailed decisions to the executive agencies. And there's a problem then with what's called delegation. That is, delegating the legislative power to the executive branch. Probably 5 justices now, maybe 6, have expressed concern with that kind of congressional delegation. So we could see, not in some sexy case, it'll be some interpretation of some subsection of the bankruptcy code or something, some pushback on that, forcing Congress, putting the ball back in Congress's court to make these decisions rather than just passing the Truth, Beauty, and Goodness Act of 2020, washing their hands of it. And then when people complain, the congressman can say, no, your complaint is with that bureaucrat because I just voted for Truth, Beauty, and Goodness.
Well, so you said something interesting in your explanation just there that I wanted to pick up on, which was you said, the primary goal of the Supreme Court is to take a look at what Congress is doing, not necessarily what the president is doing. Because my question that I had in mind was, we've seen Joe Biden sign 37 executive orders in his first week in office. And if that's a sign of things to come, I'm sure there's going to be a ton of things that they're going to try and pass through Congress during his first term. So I'm curious if you think that do you anticipate that there's going to be a lot of cases that are at least tried to be brought before the Supreme Court on a lot of the things that Biden is going to try and pass?
Well, it depends. Because on the one hand, if you live by the pen and the phone, you die by the pen and the phone. Most executive orders are just directing parts of the executive branch to enforce the law in certain ways. And that's the president's power to do so. The problems start when that interpretation of how to enforce the law, there's a challenge to that it's not plausible. So if all Biden is doing is reversing Trump's executive orders, there's less of a problem. If he tries to put in, say, cap and trade in terms of regulating greenhouse gas emissions for his, climate change is a big part of his agenda. If he tries to put in more racial preferences and things in terms of how he enforces civil rights laws, that could be a problem. So it just depends. Already the blanket moratorium for 100 days on deportations has been stayed by a court. Why? Because it's blanket. The law says that the executive branch, when there is an order of deportation, the attorney general shall remove. On the other hand, when there's kind of during the course of the process, this is where Obama got in trouble with DAPA and DACA, is if you have an individualized review of a case, there's more prosecutorial discretion. But if you have a blanket standard, then that starts violating statutes. So again, the devil is in the details, but the short answer is yes. With Congress so divided and not being able to name post offices basically, and so much policy of the policy agenda being driven through either executive action or regulation, right? And agencies promulgating regulations, there are going to be a lot of lawsuits in that regard.
Yeah, and you definitely, especially on Facebook and social media, you see a lot of people throwing around the word unconstitutional. Really make you stop and question, okay, what are they calling unconstitutional? And is it really unconstitutional, or do you just not like it?
That's true. By the way, I'm gonna put in the chat here the link to that Robert's Rules article that I mentioned.
Thank you. We were talking before we came on, about the Biden administration has come up with a commission, and this is something that was talked about during the campaign, the notion that the courts need to be reformed. And your book does a great job of describing some of the different reform proposals. Now it does kind of go back as I think you describe, or I know you describe, as this kind of high stakes notion about confirmation battles. And some of the ideas are intended to alleviate that. For example, having term limits or expanding the courts. You want to elaborate on kind of where those ideas might come out?
So a lot of people are dissatisfied with where we are in terms of our judicial battles, that there's a toxic cloud that envelops the Supreme Court, and it's just the same part of the dragged into the muck that the rest of our public discourse in. And so people try to think of ways of dialing down the temperature. Term limits is batted around probably most often. I'm amenable to term limits in the sense that if you had an 18-year term, that's kind of the standard number. Why 18? Because that means there's a vacancy every 2 years. 9 justices, every 2 years someone rotates off. Every presidential term is guaranteed 2 appointments. If someone dies or retires early, then you just get to fill the rest of that term, not a whole new one. That would get rid of kind of the arbitrary nature of when vacancies arise, politically timed retirements, morbid health watches over octogenarian justices, all of these things that kind of don't give confidence to the process, that make it seem kind of arbitrary and political and things like that. So that's great. But we have to recognize that that won't really change the larger dynamic we've been discussing, in the sense of the Supreme Court ruling on major political controversies, people seeing it as being partisan or politicized, the liberal justices, the conservative justices. 18 years is still a long time, so there's still going to be battles over every nomination, and it would take a constitutional amendment. So it's almost a non-starter, because there's some academics that say that, well, if you call the ones who rotate off senior justices and you let them keep their pension and all that, that's okay. But the Constitution says that federal judges keep their offices in time of good behavior. Well, if you make them senior judges, senior justices, that's a different office. That's not keeping the same office. So I think you need a constitutional amendment. Other proposals, I mean, yeah, court packing, meaning adding a number of justices. Look, in the abstract, maybe you'd want, I don't know, 19 justices. Maybe you want to continue what we had in the early years and have one justice for every geographic circuit. There are currently 13 circuits. Maybe we should have 13 justices. For that matter, I've argued that we need to break up the Ninth Circuit, not because it's liberal, but because it's too big. So maybe, 14 justices, well, however many, maybe those are good points. But how do you get from here to there? That's ultimately politicized. And so real problem. But that could be done by statute. You don't need a constitutional amendment to change the number. Now, some academics, recognizing that court packing is just too politicized and would make things even worse, and even for that matter, Bernie Sanders. This is probably the only thing on which I agree with Bernie Sanders on. During the primaries, he was asked about court packing, and he said, I'm not going to do the accent, but he said, if we do this, then the Republicans are going to do it next time they have power. In 50 years, we're going to have 87 justices. That's crazy. Indeed, that's crazy. So, and it didn't work well, by the way, the last time it was tried for FDR, serious political reversals and all that. So there are some creative variations of that. For example, you don't have permanent justices. Instead, you have kind of a rotating cast picked at random from the lower court judges. Or you have 5 Republican appointees, 5 Democratic appointees, and 5 that have to be unanimously agreed upon by those so-called partisan justices. Now, that doesn't really decrease the partisan or the politicization if you give explicit partisan labels to a certain number of justices. Anyway, I could go on. There's all sorts of things that people throw on the wall, try to propose. The thing is, all of these things are nibbling around the edges, rearranging deck chairs on the Titanic. They're dealing with process concerns when the problem is the product. The Titanic, the ship, the problem is the ship of state, is the size of the government. And again, this divergent theories mapping onto partisan preference at a time when the parties are ideologically sorted. So the only way to fix things, to turn down the heat on our confirmation battles and all that, is to rebalance, for the court itself to rebalance our constitutional order, push decision-making back down to the states and the people, rebalance it within the federal government to force Congress to make decisions rather than administrative agencies. Because at the end of the day, we have a very large country with a lot of different views, a lot of different backgrounds. There's no reason that Washington needs to be deciding so many one-size-fits-all solutions for the whole country. Let California be California and Texas be Texas and Maryland be Maryland. That way, you're going to have a lot fewer disagreements and political controversies for the court to fight over, and therefore each vacancy will be less fought over.
I think it should be done almost like jury duty. You get called for jury duty. This is your Supreme Court case, numbers 1 through 10, you get to do it. But yeah, and this might be a totally improper use of the word precedent here, but I'm curious that if they had managed to pass a constitutional amendment on term limits for Supreme Court justices, do you think that and this is where it comes into precedent, does that set a precedent for what Ted Cruz is trying to do now in setting term limits for Congress, or are they two totally separate things?
Well, I mean, a constitutional amendment is not a legal precedent. It's not a court decision. It's if you have the political will to pass that, then you can. Probably 20 years ago, I was, like a lot of people, was probably a fan of term limits for Congress. Now, not so much, because we have a lot of experience in the states. There are a lot of states that have term limits on their state legislators, and it has no correlation to whatever you might want to correlate it to. good policy as anyone defines it, whether you're progressive, conservative, libertarian, limited government, fiscal.
Corruption is the way that I'm viewing.
Right. Corruption. None of these is not correlated to anything. Why? Because even as you're limiting legislators, you're not, obviously, because you can't really term limiting lobbyists, bureaucrats, congressional staff, all the rest of it. And so it's there's a lot. In theory, 20 years ago, 30 years ago, when it was first proposed, there was a Supreme Court case over it. It seemed like a fresh reform. But it turns out doesn't have much of an effect. Now, the dynamic is different with Supreme Court justices because or federal judges for that matter, because they do a different role. It's kind of a different kind of public choice analysis.
Interesting. You did a discussion on an idea that I had never heard before, this idea of rotating judges in to be on the Supreme Court, sort of like doing jury duty, except you do it on the Supreme Court. And it was interesting as you thought through some of the dynamic of what does that do to precedent? Does that encourage the
zigzag? Makes a lot of
zigzag, or does it do people try and shoot for the to have their impact while they're on the court and end up kind of pushing? So it was an interesting.
I think that's right. And moreover, you would, to the extent that our lower court nominations are politicized or kind of high profile, that would only make them more so, because now there are 179 circuit judges at the federal appellate level, and all of them are kind of thought of as potential justices, or many of them, because, most justices in the last 50 years have been elevated from the circuit courts. Well, if all of the justices are literally directly picked at random from among these lower court judges, then you're only politicizing even more their confirmation processes.
One of the things that I don't think you talked about in the book, but you touched on it somewhat, is this transformation and the change that's taken place where I'm trying to think of the last time a non-judge was nominated. I don't know if that was Lewis Powell, but that was a much more frequent, common phenomena. Obviously, Earl Warren had been a governor and what have you, and it is a relatively recent phenomena that the pool of judges has been more narrowly coming from, actually even from the federal circuits. I think there are fewer. I'll leave you. I'm sure undoubtedly correct me. The last time as state judge was nominated. I don't know if that was Sandra Day O'Connor or not.
Yeah, but you're absolutely right. The last non-judge nominated was Lewis Powell in what was it, 1972, 73, I think. I'm blanking on the exact
roughly
year.
50 years ago.
Yeah. And he was actually the last one. He was 64, I think, when he was nominated. By far the oldest in the last 50 years. Ruth Bader Ginsburg was 60. We haven't had anybody else over 55 actually in that time. And the last state judge, you're right, was Sandra Day O'Connor in 1981. There are different reasons for this. Part of it is because we sort of presidents have gotten better at nominating, kind of grooming people they think might be elevated by putting them on circuit courts for like even a year or two. John Roberts, Clarence Thomas did not spend much time on the DC circuit at all before being elevated, for example. We have to asterisk this discussion that we've had. Elena Kagan was Solicitor General. She was not a judge. Solicitor General is the government's lawyer before the Supreme Court, sometimes called the 10th Justice in terms of the prestige and all that. But in fact, her very first time arguing a case in court was Citizens United before the Supreme Court.
Is there anything, just because we're coming up towards the end of the show, is there anything we didn't cover that maybe your favorite part of your book that you were really into that you want to make sure people highlight when they see it, or anything else like that you want to cover tonight?
Well, I just want to convey that the book I think has something for everyone. It's certainly not written for a legal audience. It's written for history buffs, people who are into politics, people who want to understand kind of legal flow and decisions of the Supreme Court, and it's definitely written in a way that I've tried to make accessible. You don't need any legal background whatsoever. There's one vignette that sort of, and this is what I actually start the book off of, which shows you how far we've come. In 1962, when JFK had his first opportunity to shape the high court, he picked a man of his own generation, Byron White. They'd met in England while White was on a Rhodes Scholarship, after having been runner-up for the Heisman Trophy and spending a year as the highest paid player in the NFL, right? True Renaissance man, right? Anyway, JFK and Byron White became fast friends. White eventually became Deputy Attorney General under Robert F. Kennedy, and JFK nominated him, I think it was April 3rd, 1962. 8 days later, White had his confirmation hearing, which took 90 minutes, most of which was introductions and supporting testimony from various bar association officials talking about how great he was, during which White kind of doodled on his notepad and chain smoked cigarettes. What questioning there was, about 15 minutes worth, largely concerned White's storied football career. He was surely the last person to play a professional sport while attending Yale Law School, right? And then the Judiciary Committee unanimously approved him the same day. And later that day, so did the Senate as a whole on a voice vote. So you can imagine. I mean, the thing is, confirmation hearings, we didn't even start confirmation hearings until 1916 with Louis Brandeis, who I think actually was the most controversial nominee and nomination process that we've had. People ask me, so what's the most controversial one? Is it Thomas, Bork, Kavanaugh, Amy Coney Barrett now? No, and I'll see you 2020 and 2016, and I'll raise you 1916. Also a presidential election year, first Jewish nominee, big progressive crusader, very controversial. First time ever they decided to have hearings, but it was seen as unseemly for the nominee himself to testify, so he didn't testify, but there was lots of hearings. Took more than 4 months, the longest process between nomination and confirmation that we've had, ultimately confirmed. But then his new colleague, Charles Evan Hughes, resigned from the court to run against Woodrow Wilson in that fall's election. So again, if you think about the interrelationship about presidential politics and the Supreme Court, 1916 is the place to go. But
imagine if we had Fox News and CNN in 1916.
Imagine if we had Twitter.
Exactly.
Yeah.
I love to think about that. Like, that would be a fun side podcast. Is like, let's role play what the media would have done in this historical situation. But yeah, and the final question we have, going into the end of the show also is, we did want to, because we had a couple of people comment asking to reiterate how to get a signed copy of your book. So we'll start with that.
Right. Well, if
those are definitely the right questions for people to be asking, right?
Yeah, of course.
Those are great. They make great gifts, whatever holiday, non-holiday.
Stuffers coming up now.
Just because it's a Tuesday, whatever. So go to supremedisorder.com. I mean, you can go to Amazon and search my name as well, but you can go to supremedisorder.com. And you can order through Amazon, you can order through an independent bookstore, you can order through Barnes and Noble, whatever. In fact, the area Barnes and Nobles, I don't think I got up to Montgomery County, but all of the Barnes and Nobles in Northern Virginia and DC, I got to actually sign the physical copies in the bookstores. But anyway, you can get one and then email me your address and I'll send you a signed bookplate. My email is ishapiro@cato.org.
Yeah, and Dwight will drop that in the chat for everyone who's watching on Facebook.
I'll also put in the chat here a link to another front page cover story I had in the Washington Examiner magazine last week about Biden's approach to judicial nominations. So we'll see if I'm right about any of this.
Awesome. Lots of extra material for everybody. Well, that's amazing. Thank you very much for coming on the show. It was really, really interesting having you. Even as someone who hasn't read the book yet, I feel like I learned a ton.
It's a good history. You'll enjoy it.
Yes. Yeah, I'm excited to read. And Dwight had a good point. Good Valentine's Day gift. Tape it to a box of chocolates. Give it to somebody.
And as Mark said, there's the hardcover, but there's Kindle. There's the audio. I haven't actually listened to the audio. I have it, but I haven't. Is it a good?
Did you?
I didn't read it myself. Did the actor they hired do a good job, Mark?
Yeah, very good. Yes.
Okay.
Did they get like Morgan Freeman or something?
Yeah,
it's not
there's even CDs. If there's people who still listen to books on physical CDs, you can order those.
Get it for your grandma. She'll love it. All right. Well, thank you so much for coming on the show. Thank you, everybody who has watched tonight. Thank you, Mark, as always, for hosting. Thank you, Dwight, for running the board. And we will see everybody next week. I think we have another really great guest coming up next week, right? Who do we have next week, Mark?
Not sure yet.
Is it Reed or is Reed last week?
No, next week our guest is TBD. But the following week, we have Becky Norton Dunlap from Heritage Foundation talking about President Reagan's 40 years since he was inaugurated.
So, hey, if you think you're interesting and you want to be our guest next week, reach out to us on Facebook or email.